So I think we can slowly start as people come back, maybe holding a coffee, hopefully the coffee helping to get some energy to listen to the topic that we're going to talk about today, which I might be able to tell you something about if the slides work. And I thought to introduce the panel, I'd tell you something about what happened actually only a couple of days ago. The big company 23andMe, maybe you've heard about it in the past, is one of these direct-to-consumer genetic testing company that has sold millions and millions of these genetic tests that you get at home, you collect your own sample, you can send it for analysis, and then your genetic data is available both to you and to research. Only a few days ago, it has been sold for around 200 million. Why has it been sold? Well, it has been sold because it has filed for bankruptcy a couple of months ago. And when this happened, I had a few journalists calling me in Switzerland and asking, okay, we want to understand a little bit why are the people so concerned that had a test with this company? Why do they want, just because the company is changing ownership, why do they want their genetic data to be cancelled? And we spoke a little bit about this with this journalist, and we were reflecting on how, even though this data was provided with full consent, no one has obliged anyone to buy a test from this company, get it at home, collect your own swab, send it. So it's completely free and informed if you want to talk about consent. But why do we still intuitively think that there's something ethically and legal at stake when it comes to genetic data? And this tells us that there's something special, maybe something beyond just individual consent, individual privacy about genetic data. Let me try to give you another example. This building is the Institute for Forensic Medicine at the University of Bern, another city in Switzerland, and I was there having a coffee with a colleague a few weeks ago because they provide services of forensic molecular biology. So they have a few genetic databases, and one that they use quite often to help investigators is a genetic database where when there is a crime and then an investigator finds some DNA on the scene, then they find a suspect, the DNA seems to match, then you go to this institute and you ask, based on your genetic database, what are the chances that this is an actual match, or can you please check someone in your genetic database with a similar profile in terms of ethnic group to try and calculate what is the probability that this is actually that person that was on the crime scene, or that it could be just a random person. How frequent are the genetic traces that we found there in the ethnic group of the suspect that we have identified? So in a way, what is special about this genetic databases is not just the individual person, but it's the ethnic group. It's the demographic data that is contained in these databases that makes it special. And what about the use, for example, of genetic databases that have been collected during criminal investigations for research? Well, as you can see, there are a lot of questions that are raised by genetic data, their secondary use for research. And this is the topic of today's panel that has been organized by the Health and Aging Law Lab of the Free University of Brussels, titled Global Perspectives of Regulating Genetic Data in Scientific Research. I am Andrea Martani, and I am from the University of Basel. I have the pleasure to moderate these panels in which we have excellent speakers that will first all give us an input talk, a very short input talk, looking at the general conceptual framework for the regulation of the use of genetic data, and then exploring how different legislation do it. And then we will have, at the end of these input talks, time for discussion. Now for the first one, we have Roisin Costello, Professor of EU and International Law in the Law School at Trinity College Dublin from Ireland, and a practicing barrister. In her input, she will reflect on how the traditional notion of privacy and maybe even informed consent as an individual right, which underlies, I would say, the regulatory structure of our data protection law in many countries, is challenged by genetic data use and reuse for research.
Thanks so much, Andrea. So I'm going to, I suppose, give a little bit of a framing for what's going to come next and talk a little bit about maybe the conceptual stakes for what we're speaking about in more practical terms later on in the panel. So one of the very fundamental issues, and perhaps the most fundamental issue in privacy in the late 20th and 21st century, is this idea of individual control and autonomy. So when we talk about modern privacy, we're often talking about privacy as control, privacy as consent. An idea of privacy is fundamentally linked to a dignity that is based on free choice. And in my research, I'm concerned with, both in terms of the area I focus on and the issue I think is perhaps of note and needs to be resolved, the idea that that kind of view of privacy, which is very much influenced by an idea of rights as being individualistic concerns under a kind of Hochfeldian schema where you have an entitlement and that burdens somebody else. They are obliged to fulfill the thing you are entitled to. How that can break down when we look at certain kinds of data and how that kind of individual model may in fact not be the most appropriate in all cases, and certainly can't be the universal model for how we think about privacy specifically. So it may work for other individual rights, it may work quite well. It may work quite well for things like freedom of expression, but it may work less well for privacy. So when I talk about the idea of individual rights and the idea that privacy is individually actioned, what I'm actually concerned with as far as genetic data is concerned is the idea that that data is not held individually. While we might consent to its particular uses, if we take the example of 23andMe, to undertaking a test, to the specific uses of our genetic data for diagnostic purposes, or mainly, or even simply for quite kind of leisure-related purposes, for curiosity in terms of our own family research. Those are all individual choices and they relate to our genetic data. But that genetic data isn't universally or exclusively ours. So it also belongs to those individuals to whom we are related. So the EDPB has talked about this as being a biological group, as a fundamental unit, and a unit who are implicated in privacy decisions. And why is that problematic? Well, it's problematic because we think of privacy as something we can individually control, that I can make a decision about what happens with my data. In genetic data cases, that's not particularly helpful. I'm making that choice not just for myself, but also for other people. So it's not necessarily a model which conceptually can fulfill the kinds of claims it does for other kinds of data. It can't tell us about the kind of dignitary or autonomy claims that are implicated in that kind of individualistic model, or how they transmute to those kinds of collective or relational data issues. Perhaps more importantly, when we're talking about privacy as this kind of individualistic right, we talk about it as a right which is separable and severable. So the idea that I have a distinct entitlement to privacy over discrete kinds of data. And as part of that, we view the right as being attached to siloed kinds of information, that you can neatly draw a line around the things that belong to you and in relation to which you have a privacy claim, and as a corollary, the right to waive or minimise your privacy to some respect. Genetic privacy and the harms that come along with it aren't so neatly categorised. When we consent to certain actions being taken in relation to our genetic data, we're not consenting to the use or the processing of certain kinds of discretely categorised data. And as a result of that, we're effectively consenting or allowing our data to be processed through other bases for other individuals to whom we are genetically related. And that becomes difficult because the harms which may be occasioned to us if we consent to the use of our genetic data are not severable or separable. We can't say they are only harms that we experience. If it's genetic data, it may also be a harm that somebody else experiences in our biological group as well. So what happens is that kind of conceptual underpinning that justifies privacy as this individualistic right related to control, to freedom of choice, to autonomy, begins to break down. It's no longer as conceptually attractive to say, well, this is all about my choice, my control over my data, because suddenly I'm also making choices for other people. And I suppose the main question for us as lawyers is how the law responds to that. To date, the answer is it hasn't really. We don't really grapple with this in any meaningful sense in practice. The ECHR has looked at a discrete number of cases that involve Article 8 claims in relation to genetic data, so Van der Velden, Akege from France. And in those cases, the court does really emphasise this idea that genetic data is important under Article 8 and to be protected, specifically because it has this group element, that the negative impacts for the applicant before the court is only part of the harm, that the relational impact is also implicated. So it also reveals your connections to other people, some of their traits, and as a result of that, the privacy harm is compounded, as it were. Of course, the ECHR isn't then interested in identifying who the members of that group are. So we still don't have an answer as to, well, if I can't just consent for myself because this has implications for other people, how do we draw the threshold for how we define the biological group? What kind of measures or methods do we use to identify from whom consent is needed, for example, or what other mechanisms can be used to allow the processing of this data? And how do we map on the conceptual underpinnings that justify the way we treat individual privacy onto these more collective privacy issues? So the GDPR doesn't prevent us from dealing with privacy in maybe a more relational or collective way. It doesn't prevent us from thinking about privacy as a right which might not only be individual but also have a group dimension. There's nothing to stop that. But equally, the status quo within the regulation, and certainly the presumptive position, is that privacy and data protection are rights which are validated and reduced on an individual basis. So there is potential, if we look at Article 8 jurisprudence in the ECHR, to read in light of the broad nature of the regulation, a kind of recognition of this kind of group genetic privacy or a more collective or relational privacy that recognises the connections between people and how privacy can be reduced not only for the immediate consenting party or the party immediately involved. But it doesn't really tell us how to do that. And certainly as a lawyer, the most fundamental issue is how to identify that group, that collective or the relational body of people. Do we say, for example, that it is within 2 generations? And how do we define that if there are particularly large familial groups involved? Is the threshold for protection higher in relation to groups who have ethnic identities that may be determinable based on their genetic information and need greater protection from discrimination? How do we prevent discrimination against individuals who can have, for example, sexual identities identified through genetic analysis, where they don't congrue to an XX or XY genetic model? So all of those are questions we can't answer as yet. We don't have answers to. They're questions I'm very interested in, and the rest of the panel are as well. But they're fundamentally related to a need to question the basic concepts that we think about when we think about privacy. If we're going to take seriously the potential of genetic information, we also need to take seriously the potential harms for the individuals whose information is being used. And that means engaging very seriously at a conceptual level and also at a practical level with the kinds of protections that need to be in place, not only for individuals, but also the people who may be impacted by the ripple effects of their individual decisions. So I might stop there, hand back over to Andrea, and then we'll move through the panel.
Yeah, and it was very interesting to know a little bit more from you how, to quote you, like the conceptual maybe underpinning really of the rules that we have for genetic data is crumbling a little bit, and maybe we do not have a solution for the future yet. And nevertheless, legislation and countries and system of laws need to put into action rules for the use of genetic data, especially for research and innovation. And now we will hear how different jurisdictions try to tackle this problem despite maybe not having resolved the conceptual difficulties underlining the regulation that you talked about. And to do so, we will move from, let's say, west to east of the world. We will start with Johanna, who will tell us about the United States and how genetic data is regulated there. Johanna Ranastel, she's a senior associate, so she is an attorney in Finland, in Helsinki. She is specialized in intellectual property and data protection law in the life science field, so very matching to the use of genetic data, especially for research, and who has experience in the US system through her studies at Harvard.
Thank you, Andrea and Roshin, for the great conceptualization of these fundamental issues. I'm now going to tell you a bit about the implications of the US regulatory approach to genetic data for research and innovation. And I'm going to start with a brief overview of how genetic data is regulated in the US. Then I'm going to tell you a little bit more about certain specific aspects of it, and then finish with the question of the day, what else beyond privacy is at play here. So first, to understand the regulation of genetic data in the USA, it's important to note that in the US there is no general privacy framework. Genetic data is regulated on the federal level by research ethics legislation and through sector-specific regulations that concern certain prohibited uses. Those would be the processing of health data in healthcare, which must be private and secure. And then there is non-discrimination legislation that prohibits processing of genetic data in employment and health insurance. Then there is also some state legislation that's very variable depending on where in the United States you happen to be. And then I also want to mention the NIH, the National Institute of Health, which is a very central body when we're talking about genetic data, because they host many of the important genetic databases. And they have a genomic data sharing policy that sets out some of the best practices for the processing of genetic data in research. But other than those, it's pretty much the ideal of free market and maximal use to gain maximal benefits from the use of the data. So let's move to look at in a bit more detail about certain aspects of this system. So first, if we think about human subject research, that requires informed consent. But in the US, this consent can be pretty broad and cover also secondary and future research. It's also important to note that this consent requirement does not apply to de-identified data, where the identifiers that directly enable you to identify someone have been removed. So the outcome is that actually research with genetic data is pretty flexible based on this consent requirement. And by the way, so this presentation is now focusing on the perspective of entities that are engaged with research and innovation. So of course there are sort of many problems with this system if we think about individual privacy, but I'm going to now skip those parts for this introduction and focus on this kind of research and innovation perspective. So another aspect of the US system is that it's really designed to facilitate data sharing. The NIH has large databases that collect and share material for research, including genetic data. So data sharing really is the starting point for the research system. But nowadays it has been recognized that genetic data bears a risk of re-identification. And for that reason, the genetic databases are now mostly controlled access and not available to anyone. Then, as a third point, I already touched upon the de-identification aspect, which means removal of specific identifying information from the data. Under the GDPR, I would qualify as pseudonymization because the data is not really anonymous necessarily. But in the US, de-identification is sufficient to make the data non-personal in the sense that it can be basically used and shared freely. With respect to genomic data, however, it has been recognized that this is insufficient to prevent identification of individuals. And for this reason, the NIH recommends that the risk of re-identification should be periodically reassessed. And in this way, genetic data is kind of dynamic in the sense that it's not permanently personal data or non-personal data, but kind of it can shift between these categories depending on what kind of technology is available. And this de-identification approach enables extensive use of genetic data despite not being able to fully anonymize it. Then if we consider industry research as opposed to purely academic or scientific research, as became very clear to many people with the 23andMe scandal, so to say, the industry research is not federally regulated in the United States. It's a very free system in the sense that if you collect data from consumers, you're basically only regulated by consumer protection and product liability rules, but the data itself you can use freely, and only specific uses are restricted. And those would be the use of healthcare data and the use of genetic data in insurance and employment. So from a legal perspective, it's actually really easy to obtain genetic data in the US. But in practice, states have very different laws regarding the processing of genetic data. They have varying requirements regarding data subject rights and the conditions for genetic data processing in different circumstances. So the system is also quite fragmented in this sense, and it can be difficult to navigate. But of course, the most important state regulations usually also become industry standards, which can have a broader effect than on the industry and how things tend to be done in practice. And as a last point, here I want to mention data transfer controls and biosecurity. Recently, the United States has started to restrict transfers of genomic data to specific countries, including China. And this applies not just to personal data, but also anonymous data. And this approach reflects the idea that genetic data can also be viewed as a national resource and a tool for politics. And if we again think about the research and innovation perspective, this requires some due diligence from entities engaged with sharing genetic data. So to wrap up, what else beyond privacy as an individual right is relevant in the US system? So the US is a system where data sharing and innovation are really prioritized. And since there is no comprehensive privacy framework and many uses of genetic data fall outside the scope of the existing regulations, research ethics plays a very central role. Also, because the system is not based on the concept of personal data or personal autonomy, the focus is more on concrete threats to individuals, and in this way, data security is a very central thing to consider. The US is also a sectoral system where only specific uses are prohibited and restricted. And these restrictions reflect I would say, protections of persons in vulnerable positions. And in that way, they protect certain the societal order by prohibiting the uses that are considered the most harmful. And then the US also recognizes the political aspects of genetic data through these new biosecurity measures that seek to protect databases and genetic resources from being used in ways that do not align with the interests of the United States. That was my introduction to this panel.
Yeah, thanks a lot thanks a lot for sharing with us this particular situation in the US, where maybe kind of the personal data level, the individual protections are not that high, especially for innovation in industry. But at the same time, there is this collective perspective of protecting national data from a biosecurity angle.
Yes, it's a very different system from Europe.
And this is exactly the system that we're going to move on now. We're going to move on the other side of the ocean, like just in terms of topic, don't worry, you don't have to move around, and see how the European Union regulatory approach towards genetic data has been recently evolving, in particular with respect to the very recently approved European Health Data Space regulation. And to tell us all about this, we have Professor Paul Quinn, professor of the Free University of Brussels and also one of the two co-organizers of this panel, founder and director of the Health and Aging Law Lab, and an expert in legal and ethical issues related to health data. Paul, the floor is yours.
Thank you very much. Thank you to colleagues for taking part. Thank you to colleague Roisin for helping organize this panel. It's much appreciated. And I would submit this panel is not just an example of how legal variation can vary across the planet, but we also have a great example of linguistic variation, having two Roisins that from the other side of the world that spell their name completely differently. I find it very fascinating. But I'm not a linguist, so I'll continue. My presentation is about Europe, and I've only got 10 minutes, so I'm just going to be very illustrative in nature, and I'm going to talk about how the regulation of genetic data in Europe is kind of trapped between this generalist and exceptionalist approach. When I use the word exceptionalist, I'm using it in a more narrow manner than you were. I'm not talking about the non-individual privacy claims. I'm just talking about how whether we subsume regulation of genetic data into generalist frameworks such as data protection frameworks, or whether they have their own. So the general message of the presentation is Europe has found it difficult to discern whether genetic data should be regulated in an exceptional manner or not. And this is continuing very much with the EHDS. I will dwell on the EHDS for a few moments at the end just to kind of make the illustrative point I'm trying to make. Genetic data profiling and complex data processing arguably arose roughly at the same time. I'm sorry to those purists out there who are historians of this matter, but I'm being illustrative. If we look back to the 1980s and 1990s, there was very much a focus on profiling for criminal use, for police use. We've got to be aware profiling at that time is something that is very much different than genetic sequencing, whole genome sequencing that we use now. It's very much a niche police thing that focuses on a small part of the genome, repeats in a small part of the genome. It's a niche practice, and it's related to the potential for very particular harms to occur in very particular circumstances, very serious harms, of course, potentially linked to misidentification, miscarriage of justice. And so it gave rise to very specific concerns. And we also have at the same time the rise of computer processing, storage, etc. And this gave rise to ever greater amounts of personal data being created, stored, used, shared, etc. And then, of course, in the early 1990s and forward, we had increased internet connectivity, sharing, etc. So the emergence of and the need to regulate data arose at these two moments, and these kind of created impetuses towards a generalist approach and also towards a more exceptionalist approach. Why? Because genetic data can be used in very specific ways by specific actors that can bring about serious harms. For example, the police, criminal justice system, certain forms of scientific resource. These create the impetus towards specialized frameworks and protections based upon specific circumstances. For example, as I will show a brief slide about in a moment, there are many frameworks across Europe to regulate DNA data banks that can be used for criminal justice purposes. However, at the same time, genetic data can be used in a myriad of other ways with varying degrees of harm. These include ways that may at present be unforeseen. And if you look at the evolution in how we conceive of genetic data from the 80s to now, you can very much see this. We're not just talking about profiling being used by the police or the very limited forms of sequences that scientific researchers would use. Now it's relatively easy to sequence entire genomes, to share them, to do it on a mass basis, etc. So new types of processing and new types of harm are being created all the time. It's very difficult to see how these will evolve. So this also creates the impetus to take genetic data up into these generalist data protection frameworks that are relatively technological, agnostic, and capable of encompassing future developments. And the GDPR, to a certain extent, is capable of doing this well. Of course, there are problems in terms of the exceptional nature of genetic data. So if we look at early specialized frameworks, we see a range of these legislative frameworks across Europe. We also see important normative influences, the Oviedo Convention, cases before the ECHR, MARPA, Z in Finland, which argue for the need for legal frameworks concerning the use of genetic data in specific circumstances, the use of personal data, and the use of sensitive forms of personal data. And then, of course, we see the rise of these big beasts, these generalized data protection frameworks. And as someone who has worked with doctors and researchers since before the GDPR, it's fascinating to see the rise of these big general frameworks that have come from relative obscurity, that have come to dominate regulation in these areas now. And this is exemplified by the GDPR. And of course, the GDPR is a very generalist framework. It applies to processing of all data, personal data, and to various categories of sensitive data, of which genetic data is one. So genetic data is taken up into this generalist framework in Europe, but as most of us probably are aware here, it does allow for some forms of exceptionalism, because Article 9.4 allows the maintenance of further member state requirements. Anybody who works in this field on a cross-border basis is very familiar with this. Member states use this to maintain different laws concerning the use of genetic data in various fields, including research, but not limited to research. Genetic testing is another area. And for example, consequently, member states have many further requirements. The one I'm most familiar with is the use of different requirements concerning consent in scientific research. For example, France has a well-known strict requirement for consent. There is a good overview in this document. I'm just showing you this because I've lifted some tables from it, so I want to give it proper attribution. So you see here that across Europe, a lot of states have used Article 9.4 to create or maintain their own specific frameworks. Many states do not. You could argue this is one of the reasons we need the GDPR to be generalist and to trap genetic data, because some states are relatively inactive in creating frameworks that are sufficient in this area, it could be argued. Some just very illustrative examples here. France, the document talks about France and its requirement for consent in research use of genetic data, but it says here the consent is not to be understood in GDPR terms, and it compares it to Ireland, which uses a strict requirement for explicit consent to be understood in GDPR terms. So you see there is a lot of variation in Europe. Even though we have this generalist framework, it leaves the room open to member states to adopt their own framework. So what consequences do we see? A lot of fragmentation still, a lot of inconsistency in terms of the requirements and whether requirements exist or not, as we saw from that table. and the fact that some states heavily restrict the use of genetic data through, for example, very strong explicit consent requirements, while other states do not. They fall upon the general possibilities for the use of other legal bases under the GDPR. And just to illustrate at the end, the EHDS arguably continues this hybrid approach. It's quite a strange, it's been an interesting journey, watching it go through the various stages to final approval. I'm just going to focus now on the issue of opt-in, opt-out, consent, etc., because there has been a big debate around this. There was a lot of debate, should people have the right to opt in, to opt out, etc. Of course, the Commission's original proposal did not envisage such a form of consent. The European Parliament's proposal, if I remember correctly, expressed the opinion that there should be an explicit opt-in for the use of genetic data. And if you look at the final version, the Commission agreed to a general opt-out for all forms of data, including genetic data in Article 7. So some form of compromise. What does this mean for genetic data? Does this mean genetic data is subsumed into this generalist position? Well, no, as with all things in terms of European legislation, you need to keep reading and reading and reading. And if you look a bit close, although the regulation is designed in general to stop member states erecting consent barriers towards adoption of data in the European health data space, there is an exception for certain forms of data where higher forms of safeguard are needed. If we look to Article 51, where this is specified, one of the categories is human, genetic, epigenomic, and genomic data. And to clarify, the regulation does not affect member state competence concerning the initial registration of personal electronic health data, such as registration of genetic data, etc. So this is a bit catch-22. You have to think it through. Essentially what it means is that member states should not be putting up barriers towards the inclusion of data in the EHDS specifically, genetic data, but they are allowed to maintain the existing barriers they had towards the digitalization, the taking of genetic data in the first place, which to my mind de facto amounts to the same thing. So in effect there is, we see this continued muddled picture where genetic data is treated differently still. Yes. And so the conclusions, the EU adopts a mixed approach towards regulation of genetic data. This is in general, generalist, with some important exceptions, and the EHDS has continued this trend. Now, this presentation was only illustrative and very descriptive. There are good reasons to argue for and against this position. Unfortunately, I don't have time to engage with those at the moment. Thank you very much.
Thanks, Paul, and I'm sure we will have at the end a lot of times for discussions, maybe also to debate, to enter into debate between the pros and cons of having a more generalist approach and a more exceptionalist approach in regulating genetic data. However, before that, in our regulatory overview, we move further east in the map of the world, and we will now hear from Ruoxin. What is the Chinese approach to the regulation of genetic data and genetic databases specifically? She's a doctoral researcher at the Law Science, Technology and Society Research Group at the Free University of Basel, and a colleague of Paul and one of the co-organizers of this panel, where she's conducting research in her PhD exactly on this topic. So we look forward to hearing from you.
Thank you, Andrew, for your introduction. Yeah, I'm very curious to have a little discussion with Joanna's presentation, because today my presentation is about China's biosecurity approach to regulating genetic data, so which is a very similar approach to US, but I think there's also a difference in the underlying logics and also the measures. So let's begin with a timeline about China's biosecurity framework and how this framework is historically established. So China began to regulate human genetic resources since 1990s, and at that time, that was to respond the Gene War of the century, which was described by some scholars. And that was a time when many foreign-funded statistics conducted genetic research in China because China has a large population and also a diverse ethnicities. And after almost 20 years, the central government of China adopted an administrative regulation in 2018. So this one is different from the EU's regulation, and this issued by the Chinese central government. And also at the same year, there was a very famous gene-edited baby scandal of a Chinese researcher, which made China criticized by the international scientific community. And in 2021, China issued a formal legislation called biosecurity law, which regulates the human genetic resources and data. And very recent, in 2023, China issued a lot of detailed rules for implementation for the biosecurity law. But at the same time, China's data protection framework is also emerging. So it arises a lot of concerns from the international scientific community because they consider that China's regulation on genetic data is getting increasingly strict. So here's a core provision in the biosecurity law about human genetics of China. In this provision, you can see that it clearly declares that the state enjoys sovereignty over the country's human genetic resources and also biological resources. So this law regulates not only human genetics, but also animals, plants, and other biological resources in China. So simply speaking, China put national sovereignty on the biological resources of the state, including human genetics. And the government treats genetic resources as a kind of critical, strategic national asset and resource. So I would like to note the term of human genetic resources in this law because it includes not only the physical materials like tissue, like organs from the human body, but also the data and information produced from the physical materials of human genetic resource. So under China's biosecurity law, there's a very, very special focus on international research collaboration. So that's why we would like to talk about this issue in the context of scientific research. For example, if you want to have a collaborative project with Chinese institution and you want to use China's human genetic resources, including materials and data, and you should be approved by the Chinese regulator before your project starts. And also in the project, you have to make sure that Chinese institutions participate in the project in a very substantive way and to make sure that Chinese institutions have full access to the research data and all the records. And if the Chinese institution in the project wants to transfer certain genetic data for research to the foreign institution and individuals, it should be notified to the regulator before your transfer. And if the regulator considers that the data you're going to transfer may endanger public health, national security, or other public interests of the country, you should be subject to a security assessment by the regulator. So here's an example in almost 10 years ago. So this is a China-UK collaborating study, and the Chinese institution sent genetic data to Oxford University without Chinese government's permission. And in the end, these two institutions received a penalty from the regulator. They have to stop the project and destroy all the materials and information producing from the human genetics. And this is a more recent example showing that how China's biosecurity law impacts the publication on the international journal. So this is an article published on Nature in 2023 by a group of Chinese researchers. And here, in the end of this paper, there is a section called data availability. Here you can see that the release of the data by the work is permitted by the Ministry of Science and Technology of the People's Republic of China. So this is a competent authority for genetic data and genetic resources in China. So we just talked about the biosecurity framework and the implication on the genetic research. And also in China, the data protection law also regulates genetic data, but in a very slight different way from the EU's approach. So China's data protection framework has been emerging since 2021. There are two pillars in the data protection framework. The one is for personal data protection, and this one is partially inspired by the GDPR. And for example, it imposed stricter rules for processing the sensitive personal data. And another one is quite interesting and unique. It's called data security law. It's actually driven by considerations like national security, economic development, and public interest. It aims to regulate non-personal data, but not all of the non-personal data. It only focuses on the so-called important data and national core data as defined in this law. So, is genetic data considered as sensitive personal data in Chinese data protection law? The answer is it's probably likely, but not absolute. Because as you can see from the Article 28 of this law, there's no genetic data mentioned in this provision, but based on our knowledge, it's very likely that if the genetic data is linked to one's biometric characteristics or one's health conditions, it should be considered as sensitive personal data under this provision. But also there's a possibility that what if the genetic data is not used to identify a person biometrically, or what if the genetic data doesn't reveal one's health condition and health information? And also, it's very interesting to see in my study that genetic data may be considered as important data under China's data security law. You can see from the provision that important data may directly endanger national security, economic operation, social stability, public health, and safety. So you can see the provision is very vague regarding the scope of important data. And only in the national standards of China recognize that data reflecting characteristic and genetic information of ethnic groups as important data. And also in practice, it largely depends on the regulator's guidance and decisions case by case. So here are two major implications on research from the China's data protection law. The first one is that the international transfer of genetic data for research may be subject to government's security assessment, because that genetic data is very likely to be considered as sensitive personal data. And also there is a potential of constituting important data. And the second one is that the legal ambiguities and uncertainties regarding when genetic data could be considered as sensitive or important. So here are some concluding remarks about my presentation. So the first one is that China's biosecurity approach considers genetic data as a critical national resource associated with sovereignty, national security, and public health. And the second one is that the collective nature of genetic data is explicitly recognized in Chinese law under the data security law. But the personally sensitive nature of genetic data is implicitly mentioned. And the third remark is that the international transfer, the international sharing of genetic data may be subject to double security assessment by the government, because genetic data is regulated by both biosecurity framework and also the data protection framework. So that's all of things about my short presentation, and I will give floor to Andrew and also to the audience for the following discussion.
Yeah, thanks a lot, and also thanks a lot for this concluding remark that kind of also brought it back to the beginnings, and it was interesting to see how in different legislations, both the kind of individual aspect or individual level type of protection for genetic data is recognized, for example, in the EU with the debate on rules about opt-in and opt-out, but also the collective aspect seems to be recognized both in the US and in China for reasons maybe of biosecurity. So it was very nice for you to conclude on that remark. Conclude our input session, but start the most important part of this panel, which is the interaction between the panel and the audience. So we welcome any questions on the aspects that we have touched or on other issues that you're interested in. If I remember correctly, the people that want to ask questions should come here to the microphone. Is that correct? So just we can do the recording. So I see first there was one question there at the back and then here at the front. If we may ask you to come here and just speak in the microphone for the recording to work.
Hello. 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 My name is Nicolas. I'm a DPO in the Netherlands. I work in a DPO in a genetics research company. So first of all, thanks for all the presentations. Mind-blowing overall. So I have two questions, actually, one for the Roshin and the other one for Roshin. The first one for Roshin, I wonder if you've looked at what's going on in North America, given the regulatory framework is weird with indigenous people, right?
Yeah, so I actually, a great question. So part of my research actually did focus on, in particular, the use of data from the Havasupai tribe in the Arizona state case. So that case eventually settled before it went to trial. But in one of the interlocutory hearings, the Arizona state judge made this very interesting point that effectively he did consider this a collective data breach. So there is, I suppose, a tentative recognition, although that's an interlocutory hearing, so it's not the authority a final decision would have. But certainly I know from working with colleagues in tribes in North America that there's a specific concern about the ways in which data could be used based on that example, yeah.
Well, yeah, I mean, I don't want to expand on it, but yeah, it's an interesting point. I used to live in Canada. The whole issue in Canada is about the biopower of the state on the indigenous tribes, because actually the state in Canada remains remains the one entity that can actually define who is a member of a given tribe or a given band, right? Whereas the bands, the tribes themselves, when you go to privacy conferences like this one, they actually say they want to claim it back. They want to have the option of saying, okay, if someone's 1/32nd a member of our tribe, they're a member of our tribe, but that totally depends on the federal state. So there's that issue. For Roshin, my question is, I hope I use the right tones, obviously. I hope I didn't insult you in a way or another because of my mispronunciation. So what I'm interested in, you talked about the biopolitical aspect, the biosecurity aspect of Chinese policy, but what I wonder about is consumer protection. So I know the data protection law, but Joanna talked about the consumer protection briefly in the US, where there's some protection against discrimination. I wonder what it looks like in China, especially since I'm aware of some cases in China and in Korea of the genetic discrimination becoming a thing. But yeah, it's just a thought. So I really wonder what's going on there as a consumer. What's my relationship to data protection? And what's the expansion? What's the practice?
Thank you for your question. I think for China's consumer protection law, it's more focused on the individual level, but for the biosecurity law, it's totally driven by the country's interests, for example, the government's concerns for national security and for the biosecurity issues, for the public health issues. So yeah, if you ask what's the position of the consumer protection law in the regulating genetic data, I would say that, for example, for the private genetic testing, it still applies to the consumer protection law still applies to the private genetic testing services, but at the same time they should also comply to the data protection law and also the biosecurity law. You know, if you run a private genetic testing company, you have to collect the tissues from or blood from the individuals, but what if you collect a huge amount of samples from the individuals of Chinese people, and then it can raise the concerns of the government, and there's a biosecurity law. For example, the government may consider that you have a lot of genetic information of the Chinese people, and what if you have a cooperation with a foreign institution in the name of research? So I think those frameworks apply at the same time, but they just have different focus.
Can I ask one sub-question quickly?
Very quickly.
Okay. Is the Chinese approach to data protection structured by the fact that in the Chinese constitution there's recognition of the existence of several, I don't know how many peoples, like ethnic groups in China? Is that the logic? No, like by background I'm French, everyone's a citizen in France, right? But in China there's constitutional protection and recognition of identity groups. That's my question.
Yeah, so under the biosecurity law, because my presentation is so short, I can't cover all of the details in the law. So usually there is a threshold that if you collect a certain number of people's genetic materials, or if you process a certain amount of data about the individuals, and then you are subject to certain, for example, government approval obligation. And also there are, as you said, there are certain special ethnic groups in China, and there's a list by the regulator, issued by the regulator. So if you're going to collect the genetic data from that groups, and also you are subject to the approval obligation. So
okay, thanks.
The detailed guidance from the regulator.
Thank you very much.
Thank you. We move to the next question, but it was very interesting here to see how then, maybe to answer the question of our panel, what else beyond individual privacy, how with genetic data there are these different levels intersecting, the individual one, the belonging to a certain ethnic groups, which is the way the way genetic data is collected in a lot of databases, and then also the state level really in terms of biosecurity.
Thank you very much, and congratulations for this fantastic panel. My name is Aida Ponce del Castillo. I'm a legal researcher at the European Trade Union Institute here in Brussels. And I work on data protection from the labor perspective, but 20 years ago I got a degree in bioethics, and I did my PhD degree on the stem cell regulation, human germline regulation. At the time, bioethics had a very big role in informing the law, especially the EU law and national law as well. I remember that the bioethical committees were also very important in informing the US law, particularly the presidency councils and so on. Leon Kass was a prominent figure at the time. And so I want to, and then I changed to another part of law. I'm not a bioethicist in practice anymore. And I come to your panel and I see a totally different world from which I started with. So my first question is, what happened to bioethics today when 20 years ago it really had such a power ethically, from the human rights, legally, scientifically, to inform policy? What happened to those very strong bioethical committees informing conventions and so on and so forth? Where is it now? Because what I see today is 20 years of a huge difference, and I hope that I can get some of your illustrative answers. Congratulations.
Yeah, Paul, please.
Yeah, thank you for the interesting question and reflection. I think it is interesting. I think part of it is because a lot of the legislation we're discussing today often refers to secondary processing of data. So quite often it doesn't involve any new physical imposition on a human individual. So I think this is leading to a tendency to view it differently from classic notions of research, which traditionally involve physical imposition on the individual. I think this is the reason for this tendency that you're referring to. In some ways, sometimes I think it's a good thing also because if you look in the literature, people are often talking about an overuse of consent. And this is often because even when we're talking about purely secondary data, people still have the reflex to go back to basic notions of bioethics, etc., and overutilize consent because they're associating manipulation of secondary data as being the same as physical imposition on human beings, which should obviously always require consent. So I think this is one of the reasons that because we're going to increasingly to a world where secondary data research is becoming the norm, I think this is why maybe bioethics is less called upon.
Let me try maybe to expand on this and involve also Johanna, if it's okay for you, since you mentioned that part of the regulatory framework in the US for the use of genetic data also kind of indirectly derives from how academic research is regulated, which of course then also involves to some extent, bioethics principles or a certain bioethics way of thinking. So I wanted to ask you maybe if you could expand a little bit on that and on how the regulation of traditional maybe academic research, maybe even directly with contact with people and the involvement of research ethics committee has informed or not informed the regulation also of the use of genetic data.
Yeah, thank you. I would say that the existing US laws are very much based on bioethics. Many of them are quite old laws as well these days. And those, as Paul said, those were originally based on the idea that there is a physical intrusion into the human body, and that has been the basis for the sort of bioethics discourse. And I think the way, the way that the U.S. regulations have been drafted it's very visible that there has been a scientific consultation in the way things are defined and what kind of terms are used. But then now we have so many new ways to use genetic data and things that can be done without any involvement of like a physical person. So I think that's where kind of the bioethics drops out.
Yeah, thanks a lot. And we hope we addressed at least in part some of your concerns. Of course, they are not exhaustive answers, also because the relations between human rights law, for example, and human rights also as a sort of philosophical underpinning of law and hard law, it's difficult to explore. In the same way, also the relation between bioethics or other ethical theory and law. But we hope we addressed a bit of your question. Now a time for another question.
Hello, good afternoon. My name is Wenkai Li. I'm a researcher at VUB, also a colleague of Paul and Roisin. I want to ask a follow-up question on the collective dimension of the impacts of the use of genetic data, which has been mentioned multiple times in the panel and also throughout the discussion about genetic data in general. So arguably, the collective impacts is something that is different from the individual impacts or harm or risk that can be suffered by individual people. So I think some of the speakers mentioned there is this somewhat recognition of the collective dimension in both US and China. And was wondering if there is any concrete mechanisms to address these collective impacts. And also from my research, I know in the EU legal framework, this is almost not addressed in the law because GDPR is primarily individualistic. And also in the EHDS, there's not specific measures to deal with this issue. So I was wondering what can be done to address these kind of impacts at group level. And also we mentioned indigenous groups previously, and I was wondering, so in some countries, there are legal frameworks recognizing the collective rights of indigenous groups in North America and also in New Zealand, Australia. So I was wondering if that can be an inspiration for other jurisdictions to address these questions, maybe like to expand the collective rights into like other groups of more like general classification of groups apart from indigenous people. Thank you.
Thank you. There's a lot to unpack here. Who wants to give it a go? Paul, please.
Perhaps I should have. Do you want to go first, Roshan?
No, you go.
Okay. Personally, I'm skeptical about binding legal frameworks that recognize these exceptionalist natures of genetic data, because if you examine them in detail, they always seem to lead to absurdist outcomes. For example, should you have a veto over your twin using their data for research? Or to take an example of somebody in the Native American tribe that was discussed, what if 10 people from the tribe wanted that their data was researched upon? What if 40% wanted it? What if 60% wanted it? There are always absurdist outcomes when you create a legally binding framework to give rise to a group nature of genetic data. And I don't see any way of avoiding these absurdist outcomes unless we just look at it as an individualist way. That's not to say that we shouldn't look at it ethically through this lens, because it is important, of course. But I cannot, I've not ever seen a proposal for a legal framework that can avoid these absurdist outcomes, personally. This is my view.
Yeah, so I suppose I'm a little bit more hopeful than Paul, perhaps, in respect of to the extent to which the law could potentially recognise certain kinds of collective rights in specific circumstances. I suppose the big thing I trip up on is how you define the group to avoid that kind of outcome and the kind of pushing it to the almost absurd level. So I suppose that the primary issue in relation to genetic privacy is that ultimately the largest group is all of humanity, and that all genetic data is shared, and that you work down from there. And there may be some groups who have very neatly defined characteristics on which basis they could be opting in, but there may also be groups who share perhaps an identity but not necessarily a genetic commonality. So I think it becomes quite messy. So the Irish population is probably a good example. It's a genetic group that was traditionally very homogenous. There is a very disproportionate evidence of certain kinds of genetic conditions. So ostensibly there's a certain commonality there within the population. But do you make the population group for the purposes of collective privacy? Is that the group? Just become the national group? And then to what extent does the arrival of the new Irish start to mean that group doesn't exist? So I think it becomes really difficult. Indigenous groups in North America face a certain degree of that in relation to the self-selection into tribes for certain tribes and the way in which tribal membership is governed. And that means that while they might be a contiguous identity group in terms of heritage and personal belief and many other factors, they're not necessarily genetically contiguous. So I think it becomes quite difficult. So I, similarly to Paul, while I'm more hopeful, I really struggle with how you would actually define that threshold and how you'd get into membership,
Yeah, thank you for your answer. If I can have a very short follow-up.
Very short.
Yeah, so I would agree with the opinions of two of you, but I think what we should think is not only the control of data by the group, but also the collective impacts of data use, for example, discrimination, stigmatization, which are not addressed by the European law. Actually, especially in the EHDS. Yes, that's my observation.
Thanks, and yeah, there's definitely a lot to unpack. We have time for maybe one last question. I just see if there is someone else that wants to ask it. Otherwise, we go for the second round.
Or can I share something to Wen Kai's question?
Absolutely, sorry.
So yeah, I agree with Paul and Roshin because it's very hard to identify the group, and also the scope of the group is very flexible. For example, it can be a national group and also a regional group or just a very small community. And what I found from China's biosecurity law is that China tries to identify the ethnic groups. But I feel like in the biosecurity law, there's no remedy for the group. What if their genetic data, what if their collective rights regarding the genetic data is damaged, or what's the impact, and what if some negative impacts happen from their genetic data? So there's no individual or group collective remedy approach under China's biosecurity law. And also, you can't find a solution from the personal data protection law because it's focused on individuals. So I feel like it's quite difficult to find a position in the legally binding instruments for the collective impacts and collective nature.
Yeah, we only have a couple of minutes more, so I would suggest that we finish with one comment, and then for the last question, we remain here at your disposal. But the panel will be officially finished after the comment from you.
Okay. Yeah, so I agree that the rights-based approaches don't really work on a collective level, but what can be done to manage privacy rights collectively is to regulate specific uses of genetic data. Like if there is consensus that we don't want discrimination in employment based on genetic data, then we can write a law that prohibits that kind of use. So it doesn't have to be a rights-based approach if we want to manage these group interests.
I think that's a very positive message on how the law could address some of these issues in the future. I thank a lot the audience for being so attentive, for participating, and I thank especially the panel for sharing so many interesting insights on these very challenging questions. The panel has come to an end. I wish you a nice continuation of the conference.